Connor? Yes, thank you.
Um, yes.
Yes, I passed them on.
Yes, I'm on, yeah.
Thank you.
Yeah, that was a nice time. Yeah, God bless her. I don't know how she puts up with me, but
Give you a chance. Anna,
present.
Lieutenant Reddy. Who's absent? Yes. Okay, so we do have a quorum. Okay, we don't have any minutes at this time. So let's begin with our one-day licenses. We have one for the Lynn Museum for an outdoor event on September 24th from 7 to 9 p.m. We have another one-day license for Hibernian for an extension of the premises for their tailgate party in the parking area on Saturday, September 25th from 1 to 7 p.m. Another one-day license for the Hibernian, again for an extension of premises for another tailgate party on Sunday, October 17th from 1 to 7 p.m. And a one-day license for the Lynn Museum and Lynn Arts for an opening reception for Salem State exhibit on October 6th from 6 to 8 p.m. And lastly, a one-day license for Beyond Walls for two events, September 23rd and September 30th from 5 p.m. to 9 p.m. What is your
I can make
pleasure?
a motion that we approve the one-day license and suspend the fee if it's a nonprofit.
Second.
All in favor?
Aye.
Aye. Okay. All right, then, here we have, a new license for Typical Centro Americano at 68 Market Square.
Thank you, Madam Chairman. I'm Attorney Sam Vitale. I represent Tipico. Roosevelt, his daughter are here. Nancy is the proposed manager. She's been tips and serve trained. And we were in front of the city council recently to get permission for the sale of beer and wine at this location. It's a mall that you may be familiar with at the end of South Common, Market Square. These folks, Roosevelt came to this country 16 years ago. He came to Lynn 13 years ago, bought a house, started a business, and has been there at that location since then. I spoke with Councilor Hogan at the time we were before the council. I want to point out to the license board, I think he put a stipulation in on the hours. My recollection is what, 10:30, I think? For 2 years. So I wanted to bring that to your attention. Debbie, you may have been there when they put that on in the council. But it's a family-owned business. Nancy works there with her father. She'd be the proposed manager. She's an American citizen. As I say, she's been tip certified. They sell Latin American, Central American food, and obviously the ability to sell beer and wine would help them in their restaurant business. I'd be glad to answer any questions. They're both here. I think, Nancy brought her certificate with her, I guess.
Oh, for the tips. Okay. Good. Thank you.
What's the capacity?
Excuse me?
The capacity?
I asked the same question because it's 42 and 42 according to what the building department tells us. 42 is the capacity. I'm familiar because I bring my secretary there sometimes to cash a check, the check cashing place, and I never leave her. I let her get out,
Okay.
go check, and then come back to the car because I'm concerned. There are other businesses there, including that check cashing place. My observation is that more related to those activities.
Now you say that there's an issue with homeless?
Yeah, there's
drinking?
there's usually one week that will come into a restaurant, so we like to change it around. But you know, we try to help them out. You know, we try to
reason I asked that question is because if you do get the license and the police comes by and they see somebody outside drinking, and even though it might be a homeless person, the responsibility is going to be on you as well.
That's why occasionally we need to have security outside.
Mm.
Just to have a precaution for what goes on in the front area.
Mm.
And because our responsibility is inside and outside.
That's,
15 years, we never had a problem with that.
mhm.
We're homeless and blah, blah. If we ask for free food, always they give us some free food. They go back out with coffee, you know.
But with the alcohol, you'll be opening up a whole new can of worms.
Exactly.
Yeah.
And if you have to sell alcohol, they start at what, 11? 11 for the alcohol, 11 a.m.?
It depends on what the license says. What time do you open? What time do you plan on serving alcohol?
Well, we like to be nice, but we like something like that.
We were concerned about the closing time, that's why I talked to Councilor Hogan about closing time. And so I think the condition he put on is after 2 years they could come back. He understood that you have the authority, but he asked us to agree, and we did, to what the councilor asked for, and I think it was 10:30.
Okay, because I'm looking at this common victual license that you have here. It's hours of operation Sunday through Saturday, 9 a.m. to 9:30 p.m.
Yeah, but the problem is that we renew it every year. With the pandemic, we were closed a lot of times, but after that, I put an application for that.
You have? Is that for next year? Because this one's for, this was approved January 1st, and it was issued January 11th. And the hours are 9 to 9:30.
What year is that one?
2021.
Yeah, because the one I have at home is at 10:30, probably that mistake.
And this one expires December 31st, 2021.
Yeah, the one I have at home is to say 9 to 10:30, probably that one is a mistake. I don't know how.
Am I reading this incorrectly? This is what's in here. But it's not in this packet, so. Where would we get a copy of an amended one if there was an amended one? Downstairs? Does this still have to go before the ABCC? Does this still have to go? So we have time to find the amended one before we vote on this that was set with ours, or?
Right, the board would have discretion on hours. I might suggest that food establishments on the waterfront and downtown do not require a special permit from the council. So if there is a desire to incorporate Councilor Hogan's 10:30 or a different time, it should be from this board. The framers of the zone ordinance, downtown and the waterfront don't require a special permit for a restaurant with or without alcohol. With the exception if you're within 50 yards of a school, but
Yeah, I think it might be a good idea to set, I agree to go along with Councilor Hogan's, I do personally, stipulation.
Yeah, I do too, but this isn't downtown.
waterfront,
It extends to Market Square?
oh, no, I'm sorry, I was thinking
Yeah.
the place over
Yeah.
by Alfredo.
It's Market,
I was
yeah,
thinking- no,
the one
I take that back.
downtown, yeah.
I
No,
apologize.
I
agree.
looked
I
at
think-
I looked at it.
Go along with whatever council.
Yep, no, it does need
Yeah.
the
Yeah.
special permit at that
Yeah,
location.
This isn't a business district.
Right.
Yeah,
I looked at that and I talked to Debbie about that. I think Jim's right about the central business district, the waterfront.
Right,
This isn't a business district, not a central business.
right.
right.
I apologize, I misspoke, that was,
No, that's okay. We'll let it go.
there is a check cashing place next to the.
I know, isn't that funny?
Next to Alfredo's, and they once got a liquor license years and years and years ago.
Well, I can see granting this license with the stipulation that Councilor Hogan is asking for. I think that's fair.
And also to, make
Find
sure
out
their
the hours, yeah.
vehicular is
Yeah.
correct.
I have a question also on the closing, the 10:30. You're closing at 10:30, right? Okay. So how late do you intend to serve liquor? Exactly, otherwise they'll be coming out with beers and beer.
I'll entertain a motion.
You want to keep the stipulation for 2 years, or you want to shorten
Yes,
it?
I agree. Yes, I think Councilor Hogan.
So, I'll make the motion that we do grant a license with the stipulation to 2 o'clock for 2 years, I'm sorry. And they're also going to come back with a new permit?
Hours, right, the hours, and check on the hours. And whatever the license says, that's, the hours will go by.
And to be open from 9 to 10:30, and also no drinks after 10 o'clock.
Second.
All in favor?
Aye.
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 Thank you.
Good luck.
Good luck. You too. Okay, now we have a new license for La Fogata Columbia, 23 Central Avenue, and they are requesting that we table this. So, just need a motion to table it?
Motion to table.
Second?
Second?
All in favor?
Aye.
Okay. And then everybody had a chance to look at the police reports?
Yes.
We read some of those.
I know we don't have Lieutenant Reddy here, so, I think it might be a good idea to maybe just accept these reports for the file, subject to recall for when,
Or you can wait,
Lieutenant Reddy-
I can be honest, I didn't go through them with a fine tooth comb, so if there's anything in here that concerns you,
You-
you could have Lieutenant Reddy make a formal presentation in the October meeting and
Okay.
reserve the right if you
Right,
want to.
I'd like to know more about the Molina,
Yep.
the minor in there,
Yeah.
yeah.
So why don't we,
Make a motion for table?
we can table these as well, right?
We could table them,
Yeah.
or just,
And then he can go through them and,
okay, that'd be good.
Okay, I'll make a motion to table, and we'll review these at the October meeting.
Second?
All in favor?
Aye.
Okay. I know that one. Okay, and then we have new business, pocket licenses, renewals, outside dining, and the 2022 count. These years just fly.
Actually, I don't have the 22 calendar with me, but there are 3 pocket licenses. Lupita Restaurant on Washington Street has been closed. I'm sure it's from COVID, but Amy's doing some changes inside.
This is the big restaurant or the little corner one?
Big restaurant.
The big one, okay.
The other one is Bianchi's. And
Where is that, Deb?
That used to be where Alfredo's was, wasn't it?
Bianchi's is, no, that's the one
O'Brien's,
that-
the old O'Brien.
Okay.
Okay.
Yeah, on some,
Okay.
is that Boston Street?
Boston.
Yeah.
Boston Street, and,
JD's. JD's?
JD's, thank you,
Okay.
okay? The people that own Bianchi's and JD's are the same,
Right. I
okay?
remember, yeah. Oh, yeah, they haven't done anything, huh?
No,
Oh.
So could we have them come in our next meeting and explain what's going on? If we're not satisfied, they can turn in their license.
do you want Lupita, just to see what's going on?
Sure, to be fair. Sure.
He's also the owner of the one that is at the old sub shop. That we're not sure how a different owner got in there.
Where? Where?
It's down, it's the old Philly sub shop across from the,
Oh, yeah,
Yes.
gas station.
Yeah.
Yeah.
and they have never come in, for anything.
So everything's still in his name?
As far as my records are concerned, yes.
Okay, let's bring him in. They're gonna have to close.
And Jose also is, he's on food inspection issue from Lisa Tobin
For,
for inspection issues.
That's at the Linway property?
That is-
Corona Hacienda?
Yeah.
The Hacienda? Yeah, what's going on there? Are they still open or are they closed?
Oh, no, the Hacienda
They're open,
Grounds
right?
open, yep.
Hacienda Corona, yeah.
But his food license is suspended per Lisa Tobin. Correct?
It,
Immediately suspended. No.
It is,
I think they're serving food till October 1st, the way I read it. First it was suspended, but then they gave
yeah,
it back.
October 1st,
Yeah.
it's gonna be suspended.
Yeah.
Okay.
So I'll call him in.
Yeah. What's going on?
And the other inspection issue was La Chingada, the new place. They were issued a cease and desist, not proper paperwork.
Where are they?
They're replaced Cohen Street.
Oh,
Right.
wow. Yeah.
So they've been issued a cease and desist immediately.
Wow. So they're closed.
Yeah, well, I hope so.
Yeah, they'll bring them in.
They're brand new, so.
But how did they get in there without any permits?
The renewals are all going out next month, October, because I am emailing them all. Okay, they'll get their sheet from the ABCC and accompanying papers with that. Okay, to each individual place. If they lose their paperwork, they're gonna have to come in and ask for a copy.
Mhm.
Okay? Outside dining. Outside dining for the city the state is ending in April. If anyone, wants to keep outside dining permanently, they have to apply with an ABCC application for extension of premises. Once they do that, it'll be forever. Okay? The question I have is, are we going to add a charge to the liquor license for the outside dining edition? And is that gonna we're just gonna leave it at that? They will have to pay for the hearing fee and the ABCC application. So that'll be a $400 fee plus the $200 to the ABCC. But on every license, it will be added, extension of premises to blah, blah, blah.
Is the outside giving them an extension on the amount of people that they can have?
Is it,
That's now.
but the license is a flat fee, right?
The license, the all alcohol license is $2,500 a year. The beer and wine licenses are $1,500 a year.
So depending on how much square footage they have, it doesn't matter, it's a flat fee across the board if,
Right.
depending on what type of license.
Right.
So if you're extending the
But
premises, it
doesn't
really
matter.
doesn't matter, it's,
Doesn't matter.
I'm working with the city planner office, more relevant to sidewalks and streets. I know Cambridge and Somerville are charging a rental fee, which essentially equals whatever income Cambridge and Somerville would have made from metered spaces that they've lost on a street. And that's
Okay.
what the payment is to those two cities. Some places like Rossetti's and the restaurants on Union Street, they may not have meters, so looking to see whether everybody's
still
doing the same
assess
thing
the
we're doing right
parking
here.
space,
But
right.
if you're going to use city property, it shouldn't be at no cost, and what is a fair fee to impose. But I do agree that $2,500 is the flat fee across the board. If it's their own property, whether it's
then it's, no fee. If it's city property, then it's gonna have to
that
be.
may be what you ultimately choose to do. Boston, if you go to their website, their license board says, coming soon, permit outdoor dining regulations. So every city's doing the same thing. Kind of trying to come up with something that's fair and reasonable, particularly if you're using city property.
Now, because, go ahead.
I would stress, and I've spoken to Mike Donovan about this, that to the extent that the additional square footage kicks in some handicap laws, there may be a need for A, sprinklers, or B, bathrooms. So I urge everyone to make sure that they speak with an architect. They might like the concept of outdoor dining, but the square footage may kick them into a greater capacity and some rules and regulations that are costly to comply with.
Like sprinklers.
Correct.
Do you have a sense of how many businesses will take advantage of the outside dining?
I do not.
No, I was just curious, like if you just heard like from Aaron or many people.
Rowley's definitely has a long-term interest. Some of the restaurants on Union Street, my understanding, have interest. I can't remember the last time I saw anybody at Chow's, Rossetti's. I can't remember the last time I saw a table out there.
That's why I asked,
Yeah.
yeah.
And we're going into the winter.
And even on the nice nights, there wasn't, because only because I
Well, we
couldn't
didn't have
hang
that
out
many nice nights, though. This summer was horrible.
July.
And they also have to apply for a forever license after April for the outside sitting, right? Because right now, we're going until April, we said, on the new outdoor sitting.
We'll have to set those.
And so we going into the winter, which means that maybe not too many people kind of want to eat outside. What I'm looking at is to see, do we need to increase or do we leave it and then reconsider it later on? Once they have the new, like, ABCC regulations.
Yep, and I think it's important to note that anybody that wants to take advantage of this opportunity post-April 1st has to come in with a permanent application for you folks, so you can look at it on a case-by-case basis about the neighborhood, and you can decide, A, is the fee warranted on the proposed location as that comes in, and B, you can look into hours, outdoor hours. It does not necessarily have to be till 1 o'clock. The neighborhood doesn't warrant a 1 o'clock closing. But these will be permanent, unless there's a rollback because of problems. So I don't believe DPW is going to be removing the barriers in the winter. So
Really?
that's my last conversation, anticipating that some, if not, at least some will want to resume in the spring. It's a little bit of manpower to get those things up, and DPW was about 1 week. Everybody leaves the park and playgrounds. They focus on getting these and bringing them to where they are and dropping Jersey barriers in some cases.
I will finalize the 2022 calendar and email it to all of you this week.
Okay.
When do we absolutely have to make a decision about outside dining?
Before April 1st.
So
Okay.
we have to,
I would prefer,
Okay.
because we're going to have to start having hearings before then,
okay,
to send it to the ABCC to get them approved. So that's a 4 to 6 week period once we send it from here.
all right,
So I would say by February,
okay, oh, okay,
Okay.
right?
Yep.
Just to be sure
okay,
that it's accessible to everybody that wants it.
okay,
You need to come in and do the paperwork quickly.
okay,
And it's gonna have to be explained in depth.
okay. So will we have more information on whether or not we should charge a fee?
I would
Oh,
assume
yeah,
that, yes. As a matter of fact, the planner, Justin, at 5:16, asked me if I had time later today to talk about outdoor dining. So.
Okay. Good, all right, perfect. Perfect.
There's a letter from the mayor.
Mayor, yeah, old business. Has everybody had a chance to read the communication from the mayor and his
Yes.
request that we amend our rules and regulations regarding licensed cannabis retail establishments? Anyone have any comments or concerns?
I don't.
I don't. I tend to agree with the mayor. I think
Yep.
it's very good.
Yep.
I think we're all on the same page there. So I can entertain a motion that we,
Okay. I'd like to make a motion to allow retail cannabis establishments to operate from 9 a.m. until 11 p.m.
Second?
And a stipulation be added that the extended hours only apply to businesses which pay the city its share of revenues on a quarterly basis.
I second it. All in favor?
Aye.
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 Who notifies them?
I think they're all watching right now because there's only a few lawyers that are in this game, and they're all very excited. So they probably know right now.
All right.
Okay.
In case they want to find out, they can come up with.
I will reach out to them. Too. Yeah.
Okay.
The meeting for next month,
Okay, yeah, if we could have it at 3 o'clock?
Yep.
Is that okay?
It's good for me.
Miguel, you can't make that meeting, no?
I'm going to be away.
All right, we have a lot on the agenda, though, so can we do a different, could we do it a week ahead of time? Could we do it the second week in October? Because there is a lot on the agenda.
Certainly, you're
And-
talking still 3 o'clock, because the council meets on the 2nd and 4th. So,
If we could,
so if it's 3 o'clock on the 3rd, the 2nd
second,
Tuesday,
the second Tuesday?
depending on the agenda of the council, we could always get 302 or another room.
Can you do that, Miguel?
I can do that.
Okay. You got enough time to
Yep.
get them notice? Because there's a lot, and we're bringing in some
Okay,
folks, so
so
it's better if we were all here.
October,
Well, I think that's the 12th.
Yes, October 12th.
October 12th,
Is that okay, Pam?
Yes, yeah.
October 12th, 3 o'clock
3 o'clock?
in council chambers.
That'll be okay with the council, though, right?
I won't know the agenda until we get closer, but if not, we can go to 302.
3:02, okay.
But we'll get a room at 3 o'clock.
Okay, okay. Thank you. That'd be good, 'cause it's a lot. Okay, any other business? Motion to adjourn. Okay. Motion to adjourn? Always in order.
Oh,
I'm not certainly taking a position on that level of accountability on who should be held accountable.
Yes. Great, thank you. So Mr. Tamulis, please proceed with your testimony.
Well, good afternoon to the committee and all others present. My name is Nathan Tamulis. I'm a forensic support attorney for CBCS, and I basically get tasked with assisting the defense in addressing forensic evidence, both in their case in chief and in rebutting or questioning the Commonwealth's case against them. I have almost a decade of working for CBCS, and that means I've been through, 2 drug lab disasters, the big FBI hair microscopy issue, the problems with the breathalyzer, numerous issues with, new DNA technologies, and just kind of many other instances where the Commonwealth gets it wrong from both a legal and scientific point of view. To assist me in doing that, I actually have a decade of experience working in laboratories throughout the Commonwealth, doing quality control testing in biotech firms and also testing pharmaceuticals to determine their environmental impacts. One thing that I learned in all that lab experience was that basically in the laboratory setting, everything has to be documented and reported. If it wasn't documented, it wasn't done, is essentially the attitude that all labs have to take. We have this absolute adherence to something called GLP, or good laboratory practice. And every test involved a protocol that was pre-approved by the client and verified by the appropriate regulators. So the data that was produced is then also verified by both the client and any regulators involved. This allowed us to get, the most accurate and reliable results and to answer best the questions put forward to us, how a particular drug behaves in, say, a wastewater treatment plant. The facial recognition is likewise kind of a powerful tool. And if you wouldn't mind giving me a little hyperbolic leeway, I mean, there's not much I can think of that gets a society closer to that kind of totalitarian police state that we all fear in all of our dystopian literature and everything than the potential abuse of this technology in particular. Therefore, the precautionary principle that dictates all of our GLP testing behavior to make sure that, a particular pharmaceutical is going to not build up to toxic levels in the wastewater treatment plant, et cetera, should also kind of dictate an extremely cautious use of this technology. We must err on the side of maximum control and limited application. The government's use of facial recognition should not only be transparent, which I think we can agree, but also limited to the very specific uses and in a legislatively pre-approved and judicially verified manner. With this kind of data collection, facial recognition, we need absolute adherence to something kind of like good police practices, GPP, an actual verifiable system of control. And kind of the current law, in Section 220, does recognize this need for restraint. It was a much needed start to controlling this particular technology. And this committee itself is, further effort in that direction. So very good. But it's best to note here that there hasn't even been an annual report issued yet. So it's very difficult to judge the usefulness of the data that's being collected and how it's going to be presented. So while the current law does mandate that report, it's a long time to wait to judge the usefulness or the potential damage of the data collected. In particular, the current law mandates a court order based upon specific and articulable facts and reasonable inferences therefrom that provide reasonable grounds to believe that the information sought would be relevant and material to an ongoing criminal investigation or to mitigate a substantial risk of harm to any individual or group of people. So that is interesting language, and I'll come back to it in a second, but you have to realize that in the process, the law doesn't actually provide for much oversight of the system prior to its widespread use. It doesn't mandate any kind of validation of the software used. It doesn't limit the databases that can be used. The RMV database is initially the one kind of at issue, but it's important to note, as you've seen today, there's certainly a lot of third-party data collection that occurs and is potentially even more unregulated. The law also doesn't provide adequate limitation via that judicial order requirement because there's a lot of room in reasonable inferences and reasonable grounds to believe. If you kind of take it a little bit more as a layperson would, it seems to just say that based upon some info that provides some reason to think this search is important to a criminal investigation. Even if a court does sign off on that, it's not specific enough to protect individual rights, and it certainly doesn't limit the use of facial recognition enough. So, as we said, the current law probably does not go far enough, but there are those two bills that are proposed, H135 and S47, that I certainly think should be endorsed by this committee. In fact, I was really heartened to hear Suffolk County DA Rachel Rollins endorse this bill as well. We find a lot to like regarding them, but I would also urge one further safeguard and to get to an individual's privacy and civil liberties. And I think it should require an actual search warrant with adequate specificity. The chance for numerous searches based on minimal facts is still very possible under the current law. If there's security camera footage of a street corner where 25 people walked by, where one of those people may have been involved in a car break-in very close by that may have happened at around the same time as the footage, or maybe they were a witness or whatever, that meets the threshold of the current law. And we do want to look at limiting what would be, an invasion of privacy for such I don't want to say trivial, because no crime is really trivial, but in such a matter. So even H135 and S47, their section D1 could still be interpreted to allow for this kind of facial equivalent of a massive data dump without a warrant. The wording should read something similar to, say, like probable cause that a particular individual committed a violent felony offense, and the search will lead to evidence identifying such an individual. this allows for an adequate limitation and allows for, more importantly, a judicial oversight of the whole process. It's the only way to respect, really, in an adequate manner, the due process rights of the citizens of the Commonwealth in these cases. I just like to hammer home, as many have before me, the dangers of data mining and the broad-based sweeps that are possible under the current law. In the realm of executing a judicial order, there's still a lot of leeway there versus a particularized and specific search warrant. Bringing up, the January 6th riot is interesting because while we can all agree that, IDing the perpetrators of that kind of lawlessness is important, it does bring up the possibility of the government identifying individuals at protests that we would like to protect. If there's a brawl with police at a protest, you can rest assured that everyone present is going to be ID'd for police purposes. Hence a specific warrant for someone, say, seen throwing a punch on camera would be a much more important way of limiting the use of the technology and getting to articulable crimes and articulable identities. And while we can all agree that false arrests is a huge concern, it's really not the only concern. There's the risk of just putting the wrong individuals through the process of an investigation to determine that they are the wrong individuals. We all know that can cause a huge amount of stress. And just as importantly, it's a wasted effort by law enforcement itself. So we want to limit any kind of, basically the more specific our limitations, the actual more usefulness that facial recognition can have towards furthering actual investigations versus, going astray, so to speak. So I think the best part of this committee is that we can all agree that it is absolutely vital to regulate facial recognition. And I think kind of using that GLP principle, we need to limit and start as small as possible, essentially. We have this idea that you can just, come up with a system to start that's going to do it right. But in reality, you want to build from a small system, from some singular tests, from, a very limited set of circumstances to allow for us to collect the data and make sure it happens correctly. So that's, I think, H135 and S47 with the addition of, I think, a warrant requirement. That is the best way to allow for responsible use and control of this kind of technology. And that's about all I got.
Great. Thank you very much, Mr. Tomlis. And looks like Commissioner Dyson may have a question. Commissioner?
Certainly.
You've really outlined the gravity and the severity of the harm that can be wrought by this technology. And some have advocated as a result that there should be a heightened probable cause standard, or probable cause plus. I wonder if you could speak to that, given what you've stated.
Well, yeah, certainly. And that is not only so probable cause of, that a crime has taken place, that, the perpetrator or whatever is in this footage that we're using to identify, or as we would like to say, that a specific individual is actually the person who committed the crime, and therefore we need to identify them. So yeah, a probable cause plus, so to speak, I think is definitely the right footing, especially for using a novel technology like this to begin with.
Great. Thank you very much, Commissioner Dyson. Thank you again, Mr. Tomlis, and thank you, Mr. Grant, for your panel from CPCS. Appreciate your testimony. And just for the edification of commissioners and guests, we have a little over 10 more individuals signed up to testify, and then we have some discussion by Chair Day on some items related to future presentations. So the next person I have signed up is William Bogue. Mr. Bogue.
Hello, can you hear me?
Yes, hi, how are you?
Good, how are you?
Good, thank you. Thanks for being here.
I'd like to thank the committee, Senator Eldridge, Representative Day, and the members of the committee for allowing me to testify. So I hope that the Committee on Facial Recognition will recommend that the legislature strengthen existing facial recognition laws to ensure Massachusetts residents and visitors are shielded from discriminatory searches and other sorts of harms. I am a PhD student at MIT's Computer Science and Artificial Intelligence Lab, CSAIL, although my views here are my own, but I'm a resident of the Commonwealth and am concerned about the potential harms raised by the abuse of some of these technologies. If there's one takeaway that I've learned from my research in machine learning, and it's growing to appreciate that with great power comes great responsibility. And so even if these tools worked very well for all people, and that's a big if, facial surveillance technology has the potential to severely hamper our civil liberties, much like in the U.S. Supreme Court case from a few years ago, Carpenter. The technology, the Supreme Court agreed that technology that enables low-cost surveillance can proliferate if unchecked, and so they felt that in that case a warrant requirement was justified. And so on top of that, the just generalized harms of what can happen with these technologies if unchecked, it's not that the technology is perfect. And in fact, we've seen high-profile examples of facial recognition tools misfiring, especially on Black people and Black men, leading to the wrongful arrest, for instance, of Robert Williams, who we heard from earlier today. And so recently, Massachusetts passed reform legislation that included some provisions about facial recognition technology, and that was a step in the right direction, a good step in the right direction. But I worry that the regulations fall short for now, and one of my concerns is that the existing law, my understanding is that it doesn't provide any sort of enforcement mechanism to ensure that the public officials are complying with the law. So the prospect of government surveillance, it's incredibly concerning to me. And in lieu of clear rules, I found that institution procedures tend to have a tendency to drift towards practices that are convenient for the institutions, not necessarily the people it serves. And so there need to be clear rules to discourage and prevent the technology from being misapplied in inappropriate use cases. And so the proposed legislation H135 and by Representatives Rogers and Ramos, and S47 by Senator Cream would address that kind of concern by establishing an exclusionary rule to apply when law enforcement uses the technology in a manner that does not conform with the law. And I really hope that this committee recommends those bills to the legislature, and I thank you for hearing from me.
Great. Thank you so much, Mr. Boga. Appreciate it. Do not see any hands raised, so thanks for your testimony. And the next person we have signed up is Jake LaPerouk from the Project on Government.
Hi, can you hear me? Am I coming through?
Yes. Hi, how are you?
Excellent, thanks. Thank you for the opportunity to speak before the commission today. My name is Jake Peruk, and I'm Senior Counsel at the Constitution Project at the Project on Government Oversight, where I oversee our work on privacy and surveillance policy. In 2019, we convened a task force of expert stakeholders to examine the impact of face recognition. It concluded that any law enforcement use of face recognition should be subject to strong limits. Last year, Massachusetts enacted a police reform law which imposed limits on facial recognition surveillance. While some of its policies are valuable, the law is insufficient to guard against the dangers this technology currently poses. Fortunately, lawmakers have introduced legislation that would make significant improvements. H135 and S47, each entitled An Act to Regulate Face Surveillance. In considering this legislation, the Constitution Project recommends prioritizing 5 key policies. 1. Require that face recognition searches are based on probable cause. 2. Limit use of facial recognition to investigating serious crimes. 3. Prohibit face recognition from being the sole basis for arrests. 4. Require notice to defendants. And 5. Prohibit untargeted face recognition surveillance. I'll address each of these in turn. A probable cause requirement is a critical safeguard against abuse. It is essential to preventing face recognition from being used to catalog people engaged in constitutionally protected activities, such as protesting, participating in political rallies, or attending religious services. We've already seen face recognition used to identify peaceful protesters on multiple occasions and in multiple cities. Without probable cause requirement, police could also use this technology to log individuals' activities on a mass scale in a variety of ways and through a variety of interactions. Last year's legislation set some requirements for face recognition searches, but the probable cause rule in H135 and S47 would more effectively preclude mass surveillance and abuse. Further, because the primary police use for face recognition is to scan photos taken during commission of a crime, demonstrating probable cause should not be an onerous burden for legitimate investigative uses. And the bill contains sensible exceptions such as emergencies and identification of deceased persons. Moving on, limiting face recognition to investigating serious crimes is also a key policy area. This concept has decades of precedent for powerful surveillance tools such as wiretaps. Low-profile cases often receive little scrutiny, so it is more likely that face recognition errors will go unnoticed and that other potentially exculpatory evidence will not be sought out. This is especially concerning because face recognition can be notoriously accurate, especially for women and people of color. A serious crime limit would also prevent misuse of discretionary powers, including selective targeting of marginalized communities and dissidents. For example, in 2015, Baltimore police used face recognition to target civil rights protesters, scanning the crowds of active protesters to find anyone and arrest them if they had an outstanding warrant for unrelated offenses. By restricting the use of face recognition to investigating violent felonies, H135 and S47 prevent these risks while still permitting use for public safety priorities. Third, law enforcement should also prevent excess reliance on the technology, which can be prone to error. Misidentifications have already led to numerous documented wrongful arrests and jail time for innocent individuals. You've already heard the case of Robert Williams, and there are multiple other cases as well, similarly like his. Given the range of factors that impact accuracy, it is critical that limits be placed on how much a face recognition match is relied on, even if the technology continues to improve. Current law does not limit how much police can rely on face recognition matches, nor do H135 and S47 as currently written. We recommend that these bills be straightened to ban facial recognition matches from being the sole basis for an arrest or being the sole basis for a probable cause search. Next, disclosure requirements are also critical. As a complex forensic tool, it is important defendants can examine how face recognition was used. Many factors such as algorithm quality, software settings, and whether other potential matches were discovered or investigated could provide exculpatory or mitigating evidence that is valuable to defendants. Disclosure is key both for due process rights and also to deter corner-cutting and sloppy use of the technology during investigations. A legal requirement is all the more important because voluntary disclosure rarely occurs, a reason why despite face recognition being used thousands and thousands of times by certain departments and jurisdictions, we have yet to see many of the misidentifications it likely caused. H135 and S47 require that law enforcement disclose all use of face recognition to defendants. Finally, it's necessary to address untargeted face recognition scans of public locations. This form of face surveillance has proven notoriously inaccurate. In pilot programs in UK cities, there have been error rates over 90%. No similar vetting or pilot programs have even taken place in the United States. Even if the accuracy of this untargeted form of face recognition improves, untargeted face surveillance would still create risk of dragnet surveillance activities and mass monitoring of individuals' movements, interactions, and engagements. H135 and S47 would preempt this danger by prohibiting use of face recognition without a specific warrant for a specific engagement. We encourage you to consider these bills as you examine potential face recognition regulations and that you also support strong safeguards against this surveillance technology. Thank you for your attention and consideration.
Great. Thank you so much. I appreciate your presentation and your testimony. I don't see any commissioners with questions, so thank you very much. And we will now, next person to sign up is Erica Darag from Fight for the Future. Erica here?
Yes, I'm here. One second.
Great, thanks for coming.
Yeah, of course. Thank you for allowing me to speak. So as you said, my name is Erica Dara. I'm speaking on behalf of Fight for the Future, a digital rights nonprofit based in Boston with over 3 million members in the United States. In order to ensure that Massachusetts residents and visitors are protected from discriminatory dragnet surveillance and related harms, we respectfully request that the Commission recommends the legislature pass a full ban on facial recognition. Facial recognition poses an unprecedented threat to privacy, civil liberties, and equity. Unlike other forms of identity verification, facial recognition enables invisible and ubiquitous mass surveillance. Government agencies can use facial recognition to track individuals' movements and associations without their knowledge or consent. And at this time, private entities and businesses can also do that as well. And this leads to a chilling of free speech and free association, undermines press freedom, and threatens the free exercise of religion. Numerous studies, including one conducted by the federal government, have demonstrated that facial recognition is often racially biased, especially towards against Black and Brown people. And while the current algorithms currently exhibit bias, we're equally as concerned about bias if the technology worked perfectly. This is because the technology embodies and exacerbates the criminal justice system's wider racial bias and prejudices. Government agencies are also likely to deploy the technology disproportionately in marginalized communities, increasing surveillance of those people. In December 2020, Governor Baker signed into law an act relative to justice, equity, and accountability in law enforcement in the Commonwealth, an omnibus law enforcement reform legislation. The law, codified in Chapter 253 of the Acts of 2020, contains several provisions pertaining to government agencies' use of facial recognition technology. While we support some of those provisions, namely the creation of this commission, the regulations governing police use of facial recognition fall short of what we need. One of our main concerns with the existing law is that it only regulates facial recognition technology as used by law enforcement agencies. It neither prohibits or regulates when this technology can be used or cannot be used by public agencies of a different nature, for example, schools or local parks or other entities. The existing law also doesn't prohibit use of facial recognition by businesses or corporations. If corporations can create a warrantless facial recognition dragnet that the police can access, that is essentially as harmful as police using it themselves. In order to address this, any law needs to be expanded to prohibit use of facial recognition in all places of public accommodation under the definition of the Americans with Disability Act, similar to the Portland, Oregon ordinance. Relatedly, in its testimony today, Clearview AI claimed that it only grants law enforcement access to its facial recognition algorithm and database. However, last year, Clearview experienced data breach and its client list was leaked. According to multiple news articles detailing the leaks, corporations, businesses, and universities are using Clearview AI. In public statements about the data breach, Clearview did not deny that it sold access to its facial recognition to private entities. Like public use of facial recognition, private use of the technology poses a disproportionate threat to marginalized communities. In the interest of racial justice, freedom of expression, and free speech, and privacy, we encourage the Commission to recommend a full ban on facial recognition. Thank you for your time or for your attention and consideration.
Great. Thank you very much, Ms. Dara. Appreciate you providing testimony. Mr. Tontat, did you have a comment?
Yeah, just a quick comment. Thanks, Erica. As of early 2020, Clearview AI only serves law enforcement customers. We've had trials and with other private entities solely for the purpose of also identifying criminals like shoplifters and fraudsters of identity theft. Thank you.
Thank you very much. Do not see any questions from commissioners, so thanks, Ms. Dara. And the next person we have signed up to testify is Amy Hummel from Brookline.
Thank you. I assume I'm live. I can't see or hear myself.
Yes, we can see you.
Thank you. So I'm Amy Hummel, the petitioner of the Brookline Face Surveillance Bylaw, and I appreciate the fact that I'm able to speak today, and I appreciate your stamina, that it's 2:10 p.m. in the afternoon. So I'm glad to be here, but I'm also alarmed to be here. It's concerning that citizens have to ask our state to rein in and regulate that essentially form a non-consensual, warrantless, secret search, and that doing that using pictures that in data.
And Ms. Hummel, we've broke off there. I don't know if you want to try to turn off your video and speak to us, or I don't know if you can hear us. Ms. Hummel, can you hear us? The video is broken off. Okay. We can come back to Ms. Hummel, maybe when her video gets better. The next person we have to testify is Maddie Cropley. Is Maddie Cropley here?
I am here. Excuse me.
Okay, hi.
Hi, folks. How are you doing today? Senators Eldridge, Representative Day, members of the commission. It's great to be here today. Thank you. My name is Maddie Cropley. I'm a union librarian that works with teenagers in the city of Boston. I'm also a member of the Library Freedom Project, an organized group of librarians that advocate for and educate our colleagues in the library, and library users in our community on issues of technology and power. I have previously testified before the Judiciary Committee and the Boston City Council in support of proposed bans and moratoriums on the use and acquisition of facial recognition technology at the state and city level on behalf of both my union and the Library Freedom Project. Today I am here to testify not on behalf of any of the professional or advocacy groups to which I claim membership, but from my own perspective as someone who works with young people. I'm here today to urge you to consider both bills, H135 and S47, because of what I see going on with this technology from where I am as a person who works with young people. We're seeing surveillance technologies such as face surveillance and analysis move into our institutions, which are normally tasked with the enrichment and education of young people, alongside with all other manner of data collection stuff. Part of my work in bringing these programs and workshops on surveillance stuff to the library, I do a lot of reading and research. I read about test proctoring applications which use face analytics, including recognition to administer exams. I read about employers using face analytics like affect recognition that purports to be able to determine an applicant's mood during a job interview. And I read about facial analysis tech being deployed for access to social benefits and in housing, in medicine, in finance. Without regulation of this type of technology, we are shaping a world in which young people will have to perform the dominant paradigm and submit to invasive surveillance and scrutiny just to be able to participate in their own education, enrichment, and lives. You might be like, what is this person talking about? We're here to talk about facial recognition and police mostly. So please don't understand me. Along with the other folks here, I also want to keep this technology out of the hands of police. But by only restricting or banning the use of facial recognition technology by police, in my opinion, we do not go far enough. You'll note that the several other folks have already noted that in the omnibus bill that Governor Baker signed in late 2020, that it basically only deals with the police. It doesn't prohibit or regulate when this technology can or cannot be used by public agencies of a different nature, such as like schools or local parks, maybe libraries where I'm at, all places where young people go. So let me just get to the point. I mean, is this the kind of world we want to leave for these young people? I think we have to go further than what we've already done. And, this is a good start. These two pieces of legislation are a good start. Because whatever regulation or ban that we water down now or punt on, these young people are going to have to fight later. Are we going to prioritize the interests of police who just want more money and power, or the tech companies who want more power and profit over a future that is free of the type of scrutiny they're selling? So let's face it, they talk about slippery slopes, but we are on the slope and we are slipping. This type of tech is ubiquitous and moving into more sectors. It's getting smaller, more portable, and connected to more types of databases of personal information. These kids are going to be confronted with it every step they take through life if we don't act now. If we want safety, we have to find another way than police and surveillance. A cop or a manager with a camera and a computer cannot do safety. If we want safety, let's look to the work of the abolitionists. Let's see the work being done to develop alternatives to police in some communities in the United States. And we can do that by moving money away from systems of punishment and into communities to fund the work on prosperity and safety already being done by leaders there. So we have to do the right thing for these kids on surveillance, on police, on capitalism, on climate change, or they are going to be smoking our bleached out bones in a couple of decades. In the meantime, I urge you to consider and pass H135 and S47. And thank you for your time. I really appreciate it. Thanks. Thank you.
Great. Thank you so much, Mr. Cropley. Really appreciate you coming before the commission to testify. Are there any questions from commission members? I did not see any raised hands, so thank you very much. And the next person we have to sign up to testify is Jonathan Cohen from Progressive Massachusetts. Jonathan, are you here?
Yes, Josh. Okay, good, that works. I'm less familiar with Teams than I'm with Zoom. Senator Eldridge, Representative Day, and members of the commission, thank you for taking the time this afternoon, especially for the multiple hours of this. Senator, my name is Jonathan Cohen. I chair the Issues Committee of Progressive Massachusetts, kind of statewide grassroots group in progressive advocacy, working to make a more just, equitable, kind of sustainable and democratic Massachusetts. Last year, we were very supportive of efforts from the legislature to pass kind of police reform and accountability legislation. Would have loved for it to go further than it did, but happy that as much in there got included on issues around standards for police professionalization, as well as stronger limitations on the use of force. But there is more work that needs to be done, and regulating facial surveillance technology is one of those areas. The regulations that got into the bill have a number of kind of loopholes or limitations, so to speak, that the regulations that passed only regulate facial recognition technology as used by law enforcement agencies. As some earlier testifiers noted, that it doesn't include the use of other public agencies, such as in schools or local parks departments. The regulations don't establish any limitation regarding who can directly use and operate a facial recognition system, and have fairly weak standards governing police requests and court orders. They lack kind of the due process protections for defendants who have been subject to the use of facial recognition systems, and they lack any kind of strong enforcement mechanism to ensure that public officials comply with the law. As we all know, passing the laws is only step one. We need to make sure that any laws are implemented and followed to both the letter and the spirit. We're also hearing her to testify in support of the bills noted by some other testifiers, H135 and S47, an act to regulate face surveillance by Representatives Rogers and Ramos in the House and Senator Cream in the Senate, which do help address the issues that I noted above, that these bills would, among other steps, prohibit all public entities, including schools, the Department of Transportation, and other public agencies in the Commonwealth from using and possessing facial recognition technology, create a notice and disclosure framework that would let persons know when it has been used to identify them, and establish an exclusionary rule that would apply when law enforcement uses facial recognition in a manner that doesn't conform with the law. As other testifiers have noted, facial recognition technology is kind of well documented to have racial biases built in by who's the one designing any technology. There are great books, including, I think, probably behind me, around algorithmic inequality and the other issues that scholars have been looking to in tech, as well as being simply as well as having inaccuracies. And when the possibilities of what could happen to somebody in terms of incarceration are so high, the standards of the damage that can be done, the standards needs to be incredibly high. So I encourage you to kind of view favorably upon H1315 and S47 when you decide on further regulations for facial recognition surveillance. We need strong regulations to ensure it doesn't infringe on civil rights and civil liberties, and this legislation offers a good model. And I want to thank you all for doing the work that the Commission tasked you with for the past months and however long that the Commission will be in existence to do it.
Thank you so much, Jonathan. I knew you would note about the length of the commissions of the legislature. Thank you so much. Really appreciate you taking the time. Are there questions from any commissioners? Do not see any. So good to see you, and thanks so much. Really appreciate it.
Thank you.
Next person we have signed up to testify is Catherine Gleeson from the Livable Streets Alliance. Catherine, are you here?
Yes, I'm here.
Great.
Good Good afternoon, and thank you to the Commission for the opportunity to speak at this hearing. My name is Catherine Gleeson, and I am the Policy Manager at Livable Streets Alliance, a transportation and housing advocacy group in Massachusetts. And I'm speaking up today to respectfully ask the Commission to recommend the legislature strengthen existing facial recognition law to ensure Massachusetts residents and visitors are shielded from discriminatory surveillance and other harms. As we've heard from other testimony today, facial recognition technology is prone to abuse and racial profiling, and it is important to us in our work to ensure strong regulations on this technology. Through our Safe Streets advocacy, we support legislation enabling automated traffic enforcement, a vital tool to curtail dangerous driving while reducing violent or otherwise harmful interactions between individuals and police officers. And while we support the use of speed, red light, and bus lane cameras, we must ensure that this technology has appropriate privacy regulations, respects civil liberties, and does not cause further harm to people of color or immigrants, which is why strengthening the existing facial recognition law is so important. And additionally, the use of facial recognition technology in our public spaces like streets, parks, and public transportation can turn them into spaces of surveillance. And it's imperative that this technology is properly regulated so as not to restrict the use of and mobility through these spaces. While there were some facial surveillance-related provisions included in the omnibus police reform legislation that Governor Baker signed into law in December, the regulations governing police use of facial recognition fall short of what we need, as has been explained in some previous testimony today. So I encourage you to consider Bills H-135 and S-47, an act to regulate face surveillance, sponsored by Representatives Rogers and Ramos in the House and Senator Cream in the Senate, to ensure further regulation of the use of biometric surveillance technology by government entities so that this technology does not infringe on our civil rights and civil liberties. Thank you so much for your time today.
Great. Thank you so much, Ms. Gleeson. Appreciate you taking time to testify for the commission. And looks like there is a question from Commissioner Hummel. Commissioner Hummel?
I'm not a commissioner. I was hoping to speak, and I'm trying on a new device.
Oh, yes. Forgive me. Just one sec, Ms. Hummel. Are there any questions from the commissioners for Ms. Gleeson? Okay. Thanks, Ms. Gleeson, for your testimony. And yeah, Ms. Hummel, please, we can hear you now. So.
Great. Thank you so much. I'm sorry about that. So again, I'm Amy Hummel. I brought forth Brookline's space surveillance bylaw, and I am happy to be here today. I'm going to start at the beginning because I'm not sure what you heard before. It's concerning to me that citizens should have to ask the state to rein in and regulate something that can essentially perform a non-consensual, remote, and secret warrantless search, and do that using pictures and databases that were either collected without our consent or collected for a civil purpose and then used like a mugshot. But we are here because our legal process is not equipped to legislate at the speed of innovation, and because face surveillance has been marketed and sold as a public safety solution when it needs to be treated like the threat to privacy, civil rights, and civil liberties that it is. So I am grateful that you are here trying to address these problems. So I want to talk a bit about what transpired in Brookline, because as a town, we had nearly 200 elected voters weigh in on face surveillance. Of course, I'm not speaking for all of them. I couldn't possibly, but about what I observed. So during Brookline's 4-month process, full of meetings and hearings and modifications to the bylaw draft, there were many, many efforts on the part of law enforcement to first kill the bylaw and then refer it to committee. And eventually, there was a proposed amendment to allow some limited police use. Because of all that pushback, town meeting had a lot of information and several options. So it didn't just have an up or down vote. They heard the public safety arguments, heard information about improvements to the technology, the police process, and knew about the option for occasional discrete use at the RMV. Even on the floor of town meeting, we heard these sympathetic victim arguments meant, I think, to play on our emotions. Wouldn't that be a good permissible use of the technology? Well, it turns out that even with all of that information and that process, the answer was a resounding no. Town meeting overwhelmingly supported a total face surveillance ban. Libraries, schools, public places, all included. Government use, period. The vote was 179 in favor with 9 opposed. And that amendment that would have allowed some police use failed overwhelmingly as well. A clear rejection, a red line. So I share the story because town meeting members had largely stayed out of the fray. Leading up to it, there's usually a lot of discussion, and we had a lot of discussion. I shouldn't indicate that we didn't. But until the night of the vote, the outcome was not entirely clear. But when that relatively large number of individuals were given the choice, they were resolute and chose to protect fundamental rights. Of course, the choice between face surveillance and safety is a patently false choice, and it begs the question, what kind of safety are we talking about, and safety from whom? And I think that's why you're here, and you have some alternatives behind you or before you, or that you'll support, I hope. Face surveillance, flawed or perfect, makes us all less safe because it robs us of our privacy, and that is something you can help fix. The state use of face surveillance is a government search, and if it is used, we've got to have a warrant requirement. It's just the right thing to do. I don't think we should use face surveillance at all, but because the governor has forced this issue, if we do use it, even with the warrant requirement, it must also be, as many people